Joining us to discuss, defense attorney, former head prosecutor Bob Bianchi. Of course, Bob, thank you for joining us both today. I must ask you this, because when interviewed by the police at the hospital, the doctor would answer every question indicating he really didn't know what happened. He would say, well, I don't think I hit her. I think I put a rock on top of her. Well, I think I must have. And all of these ways of phrasing answers to me means he doesn't really know what happened. And how can you then say, oh, I did it in response to her starting it and attacking me first?
Yeah, it's an interesting perspective, Judge, and it's good to be back with you guys. Thanks for having me. So I think what I was talking to your producer about before we went on air was that where the defense is going with this is in Massachusetts. There is what we call not a not guilty, but rather a passion provocation manslaughter that they're seeking. And the difference there is a life sentence for murder versus passion provocation, which is a maximum of 20 years. My last case as a homicide prosecutor actually was exactly in that space. Was there an adequate provocation, both objectively and subjectively? 2, was the person suffering under the provoking event? Was the provocation adequate that a person, a reasonable person, that's the standard, would have reacted? Was there an inability to have a cooling off period? If those elements are met and the jury believes he did it, but he did it under those circumstances, adequate provocation objectively and both subjectively, and that there was no time to cool off, there's a significant reduction. So they're not going for the straight out not guilty here. They probably know that they can't. So I would be arguing maybe there's psychological testimony, or maybe without it even, they're going to say to the jury at the end of the day, to your point, Judge, the facts show he was so provoked. He was so agitated. He was in such a state of mental disrepair. He didn't even know what he did because he was reacting to that provocation of having been assaulted.
Yeah, and you got to wonder what the size differential would have played in that calculation.
Yes, because he's a larger man.
He's a much larger man.
Yeah, and you can see in their pictures
world-class
together.
Athlete.
Exactly.
Cross-examination, very important, obviously, to the case. But there's an art to this, because we already know that the defense is going to bring in their own fire investigator, their own expert. You already know as a defense attorney what he's going to say. So a lot of what you're doing on this cross is setting up your guy to make sure that you can really make it seem like this guy doesn't know what he's talking about.
Yeah, exactly. It'd be interesting to see where they go exactly, especially with that line of questioning, because it is true. Obviously, he didn't take photos of certain things. I mean, that would be my belief. And that is such a missed opportunity. When you're doing an arson investigation, arson homicide especially, you should, in my opinion, not only be taking numerous and copious amounts of photographs, as many as you can from different angles, but we used to walk around actually with video cameras as well, so that we can even document the people taking the pictures. And those, a lot of times, a little piece of evidence in an arson investigation can make a big deal. So it'll be interesting to see if the defense's arson expert, which, by the way, parenthetically was not called, the defense did not call an arson expert, to my knowledge, in the first case, which led the conviction to be reversed for, in part, ineffective assistance of counsel, how they're going to use this information in defense to put it in their defense expert's lap to show that there was a jump to conclusions and an ineffectual investigation.
I want to add to that a common sense question, and that is, why would she burn down her own house where she lives? I mean, think about the reality of, it's not just setting him on fire, it's burning down her own home, which I think one could argue doesn't make great sense.
I don't know, Judge. It's funny. I hate to, you hate to be doing this long enough where you keep saying I had a case just like this, but I feel like that's all I do when I'm on this network. But yeah, we had an arson where a guy just decided to light his house on fire as well, because there was an argument that was going on. There was going to be a divorce. That's kind of the motive that's going on in this case. And the guy was like, well, if I can't have this house, you're not going to have it either. And he lit it on fire. Well, I mean, people do crazy things.
Always ask Bob Bianchi, because there it is. You gave me an answer why someone would burn down their own home.
And also, I mean, murder doesn't make sense, right? So it would have made more sense if she took a gun and shot him because she didn't want to be with him, or he was yelling at her, or whatever. None of it makes sense. And at the end of the day, it's anger, right?
Yeah.
Anger can make you do just about anything.
Yeah.
You know what I mean? And you're not even thinking that way. But she did think enough to send her kids out of the house. At least that's what the prosecution
claims. And that's one other thing I want to ask you really quickly. I think you have about 15 seconds. The kids believing she did it. How do you defend that?
Yeah, that's going to be very difficult. And I think, Michael, you hit it right. I'd be hammering that as a prosecutor. She told the kids to get out of that house, and that is premeditation. I think that's a huge point, Mike. I agree.
Yeah, and they believe that's exactly what she did.
Yeah,
so that's
I
what they're
think
going
so
to testify to.
All right. Bob Bianchi, as always, thank you so much for joining us tonight.